All right, so this brings us to the last case for our case analysis, which is the DTR Nominees case. All right, so this case concerns wrongful termination and repudiation. As a side issue, this case also deals with abandonment, so where the contract, neither party continues on with their performance of the contract. In this case, the vendor, DTR, had a contract for sale of land with the purchaser, who was Mona Homes. The vendor was supposed to subdivide the land before the transaction took place. They interpreted the contract incorrectly, assuming they could subdivide the land in 2 stages. The purchaser ultimately wanted to rescind the contract or terminate the contract because of the vendor's interpretation of it. Now, ultimately, both parties argued that the other party had repudiated the contract. The purchaser argued that the vendor acted inconsistently and insisted on an erroneous view, and the breach being that they had lodged a plan which didn't accord with the plan attached to the contract, okay, in terms of the subdivision. And then the vendor, DTR, argued that the purported termination by the purchaser was wrongful and therefore was itself a repudiation. Was itself a repudiation, and that then accepted that repudiation and argued that they were entitled to retain the deposit. So the key issue that went before the High Court was whether DTR was within its rights for repudiation by Mona Homes. That is, whether Mona Homes' wrongful termination entitled DTR to terminate. Just as an aside, generally wrongful termination will amount to repudiation, okay, that then gives right to the other party the right to terminate. But here, obviously, there was a dispute around the interpretation, the proper interpretation of the contract. And here, ultimately, the court held DTR were, I guess, correct in that Mona Homes' termination was unjustified. There was a bona fide but erroneous reading of the contract by DTR, and Mona Homes' termination, whilst it was unjustified, it was not itself repudiatory conduct, okay? So the termination or the purported termination of Mona Homes didn't amount to repudiation. And what this meant was that the contract was still on foot, and as neither party had actually effectively terminated, but they used the word rescinded in the case itself. But ultimately, the contract was abandoned as neither side was willing to perform it, and in these circumstances of abandonment, Mona Homes was entitled to the return of its deposit. Okay. All right, so we'll go through the case reading guide questions. Okay, so who is suing whom for what? Here, Mona tried to repudiate the contract on the basis that not all the plans had been lodged with council in accordance with the provisions of the contract, okay? The vendor argued, so DTR argued, that the purchaser, so Mona Homes' actions, constituted a wrongful repudiation of the contract. The vendor then accepted the repudiation and treated the deposit as forfeited. The purchaser brought an action seeking a declaration that they had validly rescinded the contract and they were seeking damages. And then the vendor cross-claimed seeking a declaration that they themselves had validly rescinded the contract. So did the plan of subdivision lodged by DTR on the 25th of Feb comply with the requirements of the contract? So were they actually in breach of contract when they lodged those plans? So the answer is yes, they did breach the contract. The plan didn't comply with the requirements of the contract, and that meant that they were in breach of condition 4, that the plans attached to the contract be lodged for registration. So when they lodged the plans incorrectly, they were actually in breach of contract. Then the next question then becomes, so if DTR was in breach, was Mona Homes entitled to rescind on the 19th of July? Here, the majority found that Mona wasn't entitled to rescind on the 19th of July because DTR had not breached an essential term. Okay, so it wasn't a condition of the contract. the 12 months that it had, so it had a time period attached to when it had to lodge the correct plans. That time period wasn't up. Okay, so here the clause wasn't a condition. Okay, so Mona was not entitled to rescind at that time, so they were not entitled to terminate at that time. So their termination, this essentially means their termination was wrongful, purported termination was wrongful. The next question, so had DTR, by lodging a plan which contemplated two-stage subdivision, repudiated the contract? Here the majority held no, so it wasn't repudiation, although, you know, they interpreted the contract incorrectly. The lodging of the wrong subdivision plans wasn't a repudiation. And the reason was because there was evidence to suggest that DTR's interpretation was a view reasonably held. Okay, so here, what essentially the court's done is looked at the first argument of Mona. Okay, was there a breach of a condition? Was it a breach of an essential term? No, it wasn't. And then they've looked at the next step, which was, okay, if it's not a breach of a condition, was it otherwise repudiation? And the majority held no. And here the court stated that it was a case of a bona fide dispute as to the true construction of the terms, which aren't clear. And you can see that at 433 of the judgment. And that being so, Mona was not entitled to rescind on grounds of repudiation for the anticipatory breach. Yeah, so they weren't entitled to rescind on grounds of repudiation. Okay, so what this means is Mona doesn't have a right because of the nature of the term, and they don't have a right in repudiation. So they have no general law right to terminate here. What this means is that their termination on the 19th of July was actually wrongful, okay? So why then, so the question goes on, so why then was DTR not entitled to regard it as being a repudiation of the contract, entitling DTR to terminate on the 19th of July? So as I mentioned before, generally if there's a wrongful termination, then the other party are entitled to treat that as a repudiation, and then they themselves then have the right to terminate. However, here Mona's wrongful termination did no more than evince an intention not to proceed on the basis of the incorrect interpretation advanced by the appellant. Okay, a party to be entitled to rescind for anticipatory breach must itself be willing to perform the contract on its proper construction. Otherwise, it could profit from the misinterpretation. So you can see discussion of that at 434. When did the contract then come to an end? Well, after all these terminations and purported terminations and repudiations and whatever else, nothing came of it. None of them were effective. The contract was still technically on foot on the 25th of July, 1974. And then proceedings commenced 6 months later or so in December. However, neither party intended that the contract should be further performed, so it was actually abandoned at that point. And that's how, I guess, why the court ruled that the parties had abandoned the contract. Okay, so that's when it came to an end, when that abandonment was found. Now, under abandonment principles, a deposit, is returnable. Okay, so when both parties abandon the contract, a deposit will be returned. So yes, so it was returned to Mona Homes. So then, if you look at number 7, the case suggests that a party to be entitled to rescind for anticipatory breach must be ready and willing to perform the contract. So here, so the anticipatory breach was of Mona Homes, yes. But DTR weren't able to terminate the contract because it was seen that they weren't willing and able, ready and willing to perform the contract on its proper construction, because they were holding to an incorrect view of the contract. So here, the case suggests that you must be ready and willing to perform your side of the contract at the time of the other party's anticipatory breach. And we look at that ready and that obligation of ready and willingness as a potential limitation on the right to terminate, or something that can lead to that right to terminate being lost. We look at that in the overview PowerPoint on this topic. So perhaps have a look at that if you haven't seen it already. Yeah, so the case just confirms that that is the case, that is the state of play. But yeah, there is a little tension around that principle. But if you're interested in that, you can have a look at the judgment of Justice Dean in the Foreign and White case at 437. Okay. All right. Thank you for that.